Hi, listeners. Amy here. Just wanted to jump in and let you know that when we first recorded this episode, Rebecca had not yet been sentenced. However, on June 10th, there was a sentencing hearing, so at the end of today's episode, make sure you stick around for a quick update for the shocking outcome.
This podcast features criminologists discussing sensitive themes and topics. Listener discretion is advised.
When one of Los Angeles County's most respected women is booked on vehicular manslaughter charges, will justice be served or will she be above the law? This is the Rebecca Grossman story. Hi, listeners. If you tuned in last week, then you know that Meg is taking some time off to be with her new baby. So we will have some friends joining us to fill in as guest hosts for the next few weeks. Last week, we were joined by journalist and podcaster Maggie Freeling. And this week, we have two very special guests, our friends Brett and Alice from the Prosecutors podcast. And as the name suggests, they are both prosecutors. So Alice and Brett, thank you so much for joining me. I know it is, 8 o'clock your time now?
Yeah, thank you for doing this a little bit later for us. I know it's even later for you. Here in Alabama, though, we're on Central Time, God's time. So we don't have to worry about it so much. And we are so excited to be here.
I have to say, though, it's still very late. You both had a very long work day, and our listeners will know that I am usually in bed by 9 o'clock. So I hope that tells you guys how much I respect and love you all, that I am up way past my bedtime tonight for this.
Well, then we have to thank you. Truly thank you for having us here, especially because you've had a long day as well. But I think that's what makes this podcast so fun. Everything you do during the day then carries over into the podcast.
I totally agree. Brett, a Harvard Law grad, is a prosecutor in Alabama. And Alice is a former prosecutor who used to work with Brett and is now a partner at a law firm. Unlike Brett, Alice had to attend her safety school, Yale Law School. Poor baby. Brett, that was amazing. I love that so much. That's like the best.
Brett did not tell me he was
so
doing
good,
that.
though. It's
Yeah,
so.
you let me write the intro. Sorry.
It's really good. I thought it was
Stinker.
I thought it was perfection. For our listeners, Alice and Brett will be joining today to help us break down some of the many legal aspects of this case. But before we bring in Brett and Alice to help us with some of the legal aspects of this case, let's meet Rebecca Grossman. Rebecca was born on June 14th, 1963 in California. She pursued her higher education at Texas Tech University before graduating from UCLA in 2002 with qualification in broadcast journalism. Rebecca was married to one of LA's most successful plastic surgeons, and that would be Peter H. Grossman. He was the founder of the Grossman Burn Foundation, and his father founded the Grossman Burn Center. And this is a very notable medical center. This is where Anne Hetch was treated after her fatal accident, many other celebrities as well. Rebecca was named chair of the foundation in 2006, and she also worked as the publisher and editor-in-chief of the West Coast Luxury Publications, and this included Westlake Magazine, West Luxury Magazine, and Paragon Healthy Lifestyle Magazine. Prior to that, she had worked for a short time in the entertainment industry, and before that, a flight attendant. So this is a very hard-working woman. While they were very successful in their careers, the Grossmans were also very philanthropic through their foundation work, and they received human rights awards for many of their contributions. In 2007, Rebecca herself was honored by the American Heart Association as Woman of the Year for her work. And that same year, the couple was honored by Haven Hills Foundation for their work in preventing domestic violence. By 2020, the Grossmans were living in a gated community in Hidden Hills, which is a beautiful city in the Santa Monica Mountains region of Los Angeles County. Fun fact, she lived next door to Lori Loughlin. Lori we covered back in episode 56, so if you don't know that story, check it out. The couple had a teenage daughter and a middle school-aged son. They also had a younger adopted daughter named Zubaida Hassan. Now, she was a young burn victim that Rebecca and Peter had adopted from Afghanistan in 2002 so that she could be treated at Peter's hospital. And this little girl's story got a lot of media attention. It was featured on Oprah, ABC Primetime, Good Morning America. There was even a book called Tiny Dancer that was published about her recovery and her time with the Grossman family. The family also had 2 horses and 5 dogs. So Rebecca seemingly had it all. She was a family woman, a thriving philanthropist, and a highly awarded pillar in her community. Unfortunately, though, things weren't all that thriving in her marriage, as she and Peter had grown apart by 2020. They were separated, and 58-year-old Rebecca was dating again. And at the time of the events we'll be discussing, Rebecca was dating retired Dodgers pitcher Scott Erickson, and the two were headed into a disastrous evening that would change their lives. On September 29, 2020, Rebecca and Scott went out to dinner and drinks in Westlake Village, and this is a suburb about 30 miles from downtown LA. After their dinner, witnesses saw Rebecca's white Mercedes zigzagging at over 80 miles an hour through Westlake Village along a residential street. She was only a couple of minutes from her home. A second black Mercedes SUV, which was driven by Scott Erickson, was also spotted, and his car was allegedly racing Rebecca's car down the suburban street at a high rate of speed. Many describe this as almost a game of cat and mouse. They were zigzagging in and out of lanes. At exactly 7:10 p.m., 6 minutes after dusk, Scott and Rebecca's cars flew through a marked crosswalk where 2 children, Mark Iskander, 11, and Jacob Iskander, 8, were skateboarding and rollerblading with their family on their way home from a visit to a nearby lake. The children's father was running a bit ahead with the baby sister in a stroller, and their mother was just a few feet ahead of them with their younger brother. As the 2 SUVs careened down the street, the mother managed to get herself and the younger child out of the way, but could not get to the older boys in time, as they'd been lagging behind, as kids often do. Rebecca hit 11-year-old Mark and 8-year-old Jacob at a high rate of speed and continued to drive for 0.3 of a mile past where the children were struck. The impact was so intense that her airbags deployed and the SUV's engine automatically turned off. The first victim, Jacob, was thrown near the curb about 50 feet from the crosswalk. He was taken to a hospital where he was pronounced dead a few hours later. Mark's body had been thrown 254 feet away from the scene, and he was killed on impact. Rebecca was arrested on 2 counts of vehicular manslaughter after reports say that she initially fled. Rebecca was given a breathalyzer at the scene, in which she blew a .076, and then a later blood test revealed a .08 level of intoxication, and that is just at the legal limit. Valium was also found in her system. Now, the defense would later argue that the Valium was only trace amounts, and that Rebecca was not impaired at the time of the crash. Scott Erickson, age 52, was initially charged with 1 misdemeanor count of reckless driving, but his case was, quote, resolved in February of 2020. This was after a judge ordered him to make a public service announcement geared toward high school students about the importance of safe driving. I don't believe that Scott had received a breathalyzer, or if he did, it was not made public. Possibly he had some good PR people. Okay, so that's the facts here, Alice and Brett. As we move forward, I'm going to have a lot of questions that hopefully you can help me and the listeners understand, because there's a lot of things going on in this case. For one, bail was set at $2 million. And for Rebecca, this was not very much, given that her home was worth, I read, $7 million. Would you say that a $2 million bail is appropriate given the charges at this point?
So I think you have to remember the purpose of bail. Bail serves 2 purposes. One is to assure appearance, and one is to protect the community. And despite the heinous nature of this crime, I don't think anyone would say that she's generally a threat to the community. So it really just becomes, is she going to appear, something that would require her to appear? We don't typically like to hold people in jail before they're convicted of a crime for obvious reasons. So if we can take steps that will ensure someone will appear and protect the community, we generally will. So even though it may seem like, well, that's nothing for her, it's still $2 million, and that's still a significant encouragement for her to show up. So I think it probably was a pretty appropriate bail amount.
Do you think that given that she was a woman of such means, that would make her more of a flight risk?
The thing is, she would still lose the $2 million if she didn't show up. You have to collateralize that, and they can go after her house. If, in fact, they have something to go after if she doesn't show up. In these situations, I bet her attorney actually presented a lot of reasons that her ties to the community and her status in community actually made her less of a flight risk, because she couldn't be someone who flew under the radar. She goes to the grocery store, everybody sees her. She tries to board a Greyhound bus, everybody knows who she is. It's a lot to leave behind, not just fleeing charges. She's leaving behind a $7 million home. She's leaving behind probably multiple cars, not just the very nice SUV she was driving. She's leaving behind children and, all these awards she's won in the community. Those are not light things to leave behind. And if anything, I would say that the judge probably thought those worked in her favor of not being a flight risk.
That's a really interesting perspective. And it's something you can really look at it either way, because there have been cases where people of means were considered more of a flight risk. But I think you're right. It has to do with who she was in the society. In fact, everywhere in the media said she was a socialite. She was, known to everyone in the community. So I think that's a really interesting point. Charges were later increased to 2 counts of murder, 2 counts of gross vehicular manslaughter, and 1 count of hit and run. So I'm wondering now, we've seen this a lot in cases we've covered on this show, but in the real world, as prosecutors, why the added charges? Could it be because there was more evidence found? Could it be that there was public outcry? What's going on between the time that she walks out of jail on October 1st, which is 2 days after her arrest, and then all of a sudden charges, we see such an increase?
And I'm not going to say that public outcry and public pressure can never result in that kind of increased charges, but I think in this case, it's pretty clear what happened. You had these 2 kids who were killed. The presumption there is going to be there's some sort of vehicular manslaughter, even if what she was doing was just negligent. I mean, say she looked down for a second to check her text message, and this happened. Well, that would still be vehicular manslaughter. It would be a much less serious crime than the one we're looking at here. So initially, you're going to charge someone in this circumstance with what you're going to have enough evidence to prove. You start off there. You get them in custody. You get the investigation going. Then as the investigation is beginning to reveal more things, all the details that you added in, the speeding, the racing, the alcohol, the Valium, her potentially leaving the scene. All those things are going to support a much more significant charge, a charge more like second-degree murder. And I know we can talk a little bit about what distinguishes second-degree murder from manslaughter and all that at some point when we get into that. But you've got second-degree murder, the vehicular manslaughter. It's not just her looking down at her phone, which would be negligent vehicular manslaughter. We're going with gross negligence here. When it's gross negligence, it's something much more serious, a much worse action that led to the vehicular manslaughter. So all these charges are being elevated, and I think that is why you're seeing that. They started off with what they knew for sure, and then once the evidence started to come in, they realized, no, there are much more serious charges that the evidence supports.
Do you think the fact that she was not taking any responsibility for her actions, showing zero remorse, could those extra legal factors have anything to do with the charges?
So you can't bring malicious prosecution, right? Certainly the police talked to her. She probably invoked her right to have an attorney, and she is welcome to assert that right. But when the police talk to her, and let's say she asserts her right and she says, I didn't do anything, they can't retaliate by bringing charges that the evidence doesn't support. And so in this case, certainly you can charge a kind of spectrum of charges in terms of severity. And of course, the charges that were added on become more and more severe. Sometimes that can be a strategy to show kind of the spectrum of what the defendant is facing in court, to encourage them to not have to put the victim's family through a trial, for example, to essentially get justice for everyone involved. But you can't bring a case unless you have the evidence behind it. And just based on the facts you've recited here, there certainly was evidence for that. But there is such thing as malicious prosecution. I don't think this rises to the amount of it. And as prosecutors, you're not supposed to kind of dangle something like that over your defendants or witnesses if you do not have the evidence that backs it up. It's perfectly fine to say, look, we've brought these charges because there's obviously vehicular manslaughter here. We have a lot in our investigation. It's continuing to go on with all of these witnesses who are continuing to talk to investigators. We will be amending your indictment and there will be additional charges. Are you sure you want to go forward? That is not threatening because you truly have the evidence behind it. It's a fine line to walk here, but I think in this instance, even if she was willing to cooperate because of the heinousness of the crimes, I would not have been surprised if additional charges were added, no matter her response to law enforcement.
I think that's a valid point. It certainly didn't help her in the court of public opinion, that's for sure. There was public outcry because after the accident, you would expect maybe her to come forward or see her grieving or to be helping the mother or something. And she just simply, is just saying, I didn't do this, and, putting blame off on everyone else. After the accident, over 50,000 people signed the Change.org petition that was launched by people from Westlake Village. And interestingly, they were demanding, among other things, that Rebecca's mugshot be released to the public, and that her $2 million bail be revoked, and that she be put behind bars while awaiting trial. Now, I understand that they can't revoke her bail just because the public would like them to, but this idea of making the mugshot public, is this something you see often? Is there pressure on law enforcement and the media to release photos? Do they have to release photos? Is this public record or innocent till proven guilty? Some places say, no, we're not releasing this mugshot.
And, that's just going to depend on the jurisdiction. As we're recording this, they just had Scotty Scheffler got arrested at the PGA Tour, and his mugshot was out within 30 minutes of it happening.
Yep.
And I don't know what the Los Angeles County Sheriff Department's policy is, but I will say this: they should have done in this case what they would do for anybody else.
Yeah.
She should not get special treatment, and she also shouldn't be treated worse. Mm-hmm. So if they typically release mugshots, which honestly I would think they probably do,
yes,
then they should have released her mugshot as well. Not because of a Change.org petition, but because that's their standard operating procedure. And one of the tenets of our justice system is that all people are treated equally before the law.
Yep. And that's where the problem comes in, because people felt that since she was a socialite, she was getting special treatment, because in other cases, they did in fact release booking photos. Although the Los Angeles County Sheriff's Department said, quote, since a booking photo is considered part of an investigatory file, it is exempt from public records. But again, it doesn't seem to track.
And here's the thing, I don't know what the thought process was for the Sheriff's Department, but in some ways, I can imagine that the Change.org petition may have actually pushed the Sheriff's Office not to release it because they don't want it to appear that they are trying to bear public opinion down on the defendant, who still is going to stand trial, is still innocent until proven guilty. And the Change.org petition didn't say, we don't know who the person is. The name was already known to the public. So in terms of a danger to your society, we already knew who it was. You can probably Google her and find a picture of her because she had won all these awards and she was someone known in the community. And so not that that's a correct decision, but in some ways, actions by the public can actually backfire when a sheriff's department who may not always be in the limelight. Now, LA deals with a lot of celebrities, so they are actually more adept at this type of navigating public opinion than perhaps smaller sheriff's departments. But the whole point is sometimes public opinion and public pressure may actually work against what the public wants. And you can imagine if this Change.org petition has lots of bullet points: revoke her bail, release her mugshot. They may be thinking if we give on one part, or we release it because we always do, they think we are giving in on a Change.org petition, which may look bad in court if the judge thinks that we are giving into public pressure instead of meeting the legal standards that are required by law for everyone. So these are some of the things that the Sheriff's Department might be thinking, which ultimately may end up in unfair treatment. And they think that they're actually helping to protect the public, but it looks like a socialite is getting special treatment.
Now, given that it's the Los Angeles County Sheriff's Department, they're probably just doing the wrong thing.
Yeah.
they don't bathe themselves in glory in a lot of these cases.
I would also think that if they start giving in to these Change.org petition requests, then that's a slippery slope, right, for other cases. And they don't want to be inundated with every case that the public's trying to get things changed. So I could imagine there's probably a lot going on. Now, the pace of this pretrial was extremely slow, and a few of the judges commented on it. At a September 2021 hearing, Judge Shelley Samuel seemed pretty angry as she said that Rebecca Grossman had failed to show up for 5 scheduled court appointments. Now, is this special treatment? Because it's my understanding that if you don't show up to your court appointments, there can be a warrant out for your arrest, and they certainly know where to find her. So what is going on here?
So yes, technically, if you don't show up when you are required by the court can issue a bench warrant and have you arrested. That's usually a method of last resort for all courts, whether it's a socialite or your common, defendant. And the reason is that's a pretty big step to send the marshals after you or the police after you when maybe you had a bad attorney who didn't remind you of the date, or your car broke down and you weren't able to get there. So they tried to give some leeway to defendants. Now, 5 missed court appointments is a lot, but remember, this is also 2021. I bet you, because of COVID, a lot of the courts were slow moving and almost everyone was able to delay hearings just by saying something along the lines of, I have a cough, I might have COVID. My child has COVID. I am so afraid because I have a heart condition that I cannot appear before X, Y, and Z. And when you have a criminal case, it was a kind of a new world where no one was quite sure in the criminal context when Zoom was allowed, when it would be constitutional. So this was a changing landscape at the time. I don't know the reasons Rebecca gave to miss all those appointments, but I will say Brett and I, we prosecuted a lot of cases together. We prosecuted a lot of cases during COVID. And this happens more often than not. I had one defendant who was a white-collar criminal, so not quite a socialite like Rebecca, but she was a woman of means. And she missed about 10 court appointments, never was arrested for them. And each time it was an excuse. It was, my car broke down. I had a panic attack. I fell ill with the flu. My child got stuck at the doctor and we couldn't turn on our phone. And in the court, as long as there's a reason, tries not to take that very last step of having to arrest someone because it is such an extreme step. So while she may have gotten special treatment, I don't want to give defendants like extra excuses of what to say to judges. But if you can articulate some excuse, most of the time, the judge tries to be accommodating to the defendant because what is at risk? Your constitutional rights being taken away in the criminal context.
I mean, of course, this just gives the public more to go on. This just feeds the narrative that Rebecca thought she was above the law, and she seemed to believe that she was untouchable. And at the same time, court proceedings were also moving along slow because the defense filed many motions. For example, they filed a motion to dismiss all charges, which is very common. That was denied. Then they filed a motion to have the murder charges against Rebecca reduced to vehicular manslaughter. However, the judge found that there was probable cause to determine that Rebecca had acted with implied malice rather than merely gross negligence. Now, Brett, you started explaining the difference here, but can you briefly tell me the difference between implied malice and merely gross negligence?
Yeah, so basically, if you think about it, this is a case where murder or death was not intended. So no one would argue that she was trying to kill these kids, which means, it's going to fall on a spectrum of possible charges. It can't be murder 1 because you didn't intend to kill anybody. If it's murder 1, you have to intend to kill somebody. But below that, certain kinds of intent can qualify. Second-degree murder, you can be charged with second-degree murder even if you do not intend to kill someone if you have something called malice aforethought. Now, usually when you think of malice aforethought, you think of, I have malice towards someone. Like you think of sort of the colloquial sense of it. I am angry at you for some reason. I'm going to kill you. But the other form, if you've ever watched Law & Order, they love this in Law & Order, is depraved indifference towards human life. That is a form of malice. And so what the state is saying is, look, if she was driving her car, even in a grossly negligent way, that's one thing. But when she's doing it in such a reckless way, it's more than just gross negligence. It's absolutely reckless, and it ignores the danger to human life, a danger that should have been evident to her the moment she did it. And because she did that, that means it is malice aforethought and it can be second-degree murder. The most common example of this, or sort of the common example that is used to describe this, is you have a gun and there's a crowded room and you fire the gun into the crowded room. And you're not trying to kill anybody. You don't care if you hit anybody, but it's something that is so dangerous and so obviously threatening to all the people in that room that if someone's hit and killed, we're not just going to charge you with being negligent. You were so much more than negligent when you did that. And that can be second-degree murder. Here, it's not a gun, it's a car. And a car can be just as deadly, if not more so, than a gun, particularly when you're driving at 100 miles an hour through an area that has pedestrian crosswalks with children in it. And so what the prosecution is saying is if we can prove that she did that, we can prove that she had that malice that's necessary, and that qualifies for second-degree murder. And when you're making charging decisions, it's just probable cause. It's not beyond a reasonable doubt. And here, clearly, just based on the general facts of this case, there's probable cause to believe that she was doing exactly that.
How much should we weigh the fact that she had gotten speeding tickets in the past, and one of the officers who pulled her over for one of those tickets told her, if you continue speeding, you are going to hurt someone? Is that very relevant here? Because I heard that used a few times.
I don't know if that ever came into court. Typically, if I were her attorney, I would certainly argue that that is much too prejudicial. And we typically are relegated to the evidence for the specific facts here. So we always say that bad acts that you do typically don't come in because that's kind of the you're a bad person, so you're capable of this bad crime sort of case. We want to, in our judicial system, say that we have to look at the evidence for this specific time. So just because she's always speeding may not necessarily mean that she was speeding this time. So they do have to show that she was speeding this time and she was driving at that high speed in a residential area and that she also had the Valium and the blood alcohol level. But there are exceptions to that. You can bring in similar bad acts to show that there's either motive or that this is a pattern that she had noticed. And so in this instance, especially if a police specifically told her the dangers to it and she's trying to argue, I had no idea this was a pedestrian crosswalk. I thought that this was a business district and I thought the speed limit was 70. So I was just a little bit over that. Then I can see a very good reason for the judge to let in that particular statement, that particular interaction, to show that she absolutely knew the dangers of what she was doing. So it's not a bar every single time, but it's very fact specific, and it's something that would probably be litigated or at least argued among the parties whether something like that can come in.
As I often tell my students, there's really no black and white when it comes to the law. Everything is so circumstantial. And, the example you gave is such a good one where it matters so many different, did she get pulled over for speeding in that particular area? If she had, then that would be very different than if it was on a freeway, say. So again, the community, particularly the victim's family, is very upset at how much the trial is delayed here. And they were also shocked that Rebecca entered a not guilty plea. This causes people to wonder, does she really believe that she's innocent? Or maybe she thought that she could just buy her freedom because she really had quite the team of defense attorneys because, again, she was a woman of means. So it sounds like even if she took a guilty plea, they weren't going to be offering her that sweet of a deal.
Well, one thing, and we always point this out to people because this comes up a lot, you always plead not guilty, no matter what. Even if you fully intend to plead guilty eventually, because once you plead guilty, then you've lost all your bargaining power, right? I mean, once you plead guilty, you're guilty. Mm-hmm. You're not going to get anything from the prosecution. So her initial plea of not guilty is one thing. I think the question then becomes what was going on behind the scenes. As you said, if the state's like, look, we have you dead to rights, you either take it all and you can at least say, I'm accepting responsibility, throw yourself on the mercy of the court. Your Honor, I understand how horrible this was. And you talked about this before, remorse. It doesn't matter as far as charging goes, but it certainly matters when it comes to sentencing. Mm-hmm. And that is the strategic decision you have to make as a defendant. Even if you're not going to get anything from the state, sometimes you can actually use that to your advantage. Your Honor, I didn't have a deal. They didn't offer me anything. If I had gone to trial and lost, I would be in the exact same position I'm in, but I'm pleading guilty because I know what I did was terribly wrong. And I have to be punished for it. And I'm just asking you not to put me in prison for the rest of my life. She could have done that. So I do think the fact that she never accepted responsibility is a bigger problem than sort of her initial decision to plead not guilty.
And the fact that she's going to make this family sit through a trial is despicable. I think that's why she keeps just doing things that just shows the blatant disregard. And as someone who has children herself, how could she not feel empathy? It's just shocking to me that she would make the family go through this. After more than 3 years, the trial finally began on January 27, 2024. And prosecutors argued that Rebecca and her then-boyfriend Scott Erickson had been out for drinks earlier that evening, and that they were speeding toward her nearby home in separate vehicles, and that is when her white Mercedes SUV struck the boys while they were in the crosswalk. They alleged that she then continued driving after striking the boys and eventually stopped only because her engine stopped running, and this was due to an automatic feature in the car, not because she chose to. Now, the lead defense attorney, Tony Busby, contended that it was Scott Erickson who struck the boys first with his black Mercedes SUV. Why was Erickson not called to testify? Any thoughts? I know you might not know for sure the reason, but just given what you know, is this some sort of strategy? Is this good strategy? Because the defense is saying that Erickson hit the children and then Rebecca subsequently hit them. If they think that that is actually what happened, why are they not calling Scott Erickson?
There could be two things that are happening here. One could be that they know he's going to get on the stand and say, no, that's not what happened. She hit him.
Well,
I saw it. It was terrible.
That's got to be it. What else could it be?
Well, the other thing it could be is the Fifth Amendment. It's possible, and I'm not sure exactly where everything stood, that if you put him on the stand, he's just going to invoke his Fifth Amendment rights not to testify because anything he could say could result in him eventually being charged with some sort of vehicular homicide. Mm-hmm. That might not be possible given that he was charged with something and then it was resolved, like you were saying. This is speculation. But a lot of times if you have someone who's in his position, you can't call that person if all they're going to do is invoke their Fifth Amendment rights, because we just don't let you do that. So that's a possibility as well. But I think the more likely thing is you can say that to a jury and maybe they'll believe it. And maybe the jury will even fault the prosecution for not calling him. But if you know you're going to call him and he's going to say, no, that's crazy, she totally hit him, then better to throw it out there and never back it up.
I don't think it's surprising the defense didn't call him. You know, it's very common to say some other guy did it. Mm-hmm. That's the defense that a lot of defendants bring for any type of case. It's much better unless you're going to get someone who gets up there and says, I did it. You're never going to win by calling that.
And no one's going to
No one's going to say because of the Fifth Amendment. The prosecution not calling him also doesn't surprise me because they have a very straightforward case. They have the damage on the car. Mm-hmm. They have eyewitnesses. They have, the car stopping from an automatic feature, her essentially trying to get away. Their evidence is incredibly strong. They don't need Erickson. If anything, Erickson is going to muddy the waters. So in terms of strategy and storytelling, because the prosecution has the burden to prove these offenses at trial, and part of proving the offenses is also storytelling. And you don't want to have all these witnesses. You can always call a plethora of witnesses who may not actually add to your story. And jurors are real people who get tired, who get, decision fatigue when they hear too much extraneous information. Erickson is not going to say anything helpful to either side, so he's not going to be a good witness, and it's better for the prosecution not to call him.
Let me just say this, and this is taking us down a little bit of a rabbit hole that you may not want to go down.
Yeah, it's okay.
But I think there's a pretty good argument that Erickson should have been charged with murder as well, with felony murder. Yep. Now, I don't know if California still has felony murder because felony murder has kind of fallen out of favor. If it does, to me, both of their actions are felonies. I mean, they're both driving recklessly. And the thing about felony murder is you can be charged with felony murder even if you don't kill someone. So let's say you and a friend go rob a store. Your friend pulls out a gun and shoots the owner. Then you both get arrested. You can be charged with that murder because you took part in the felony that led to the death.
I see what you mean. I agree that he should be held responsible, but could it even fall under felony murder? Because Rebecca's car is the car that had the damage, right? The eyewitnesses said that it was Rebecca's car. I agree that it was actually just dumb luck, if you want to call it that Erickson was, centimeters away from hitting the mother and the first child, right? So I agree that he just, quote, got lucky. But I definitely think he would be culpable, and I was going to bring that up later. But could it actually be a felony murder? Could it be something else?
I think it depends on California's laws and how you define what they were doing. A lot of times street racing is a felony because street racing is so dangerous. And this is described by some people as they're racing home. They're sort of weaving in and out of traffic and that sort of stuff. I think you could argue that was street racing. Now, I don't know if in California or if in Los Angeles County they have street racing as a felony, or if they thought they could make this case. There also, in some jurisdictions, there's a misdemeanor version of this, or if you commit a misdemeanor and someone dies, you also can be charged with that. So even if it was just a misdemeanor, I think they probably could have gotten him for something. It just feels like he really got off light in this case.
Most jurisdictions usually have a felony for a certain number of miles over the speed limit, because this was a residential zone, right?
This was 81 and a 45.
And a 45. So 45, typically it's going to be like 30 over. Every jurisdiction is different, but I remember in my younger days when I would get pulled over, and if I was close to that basically felony line, and I was like crying because I was a 16-year-old who was being stupid, thank goodness I didn't kill anybody, the police would always be, would warn everyone, this is felony over X number of miles per hour because of what we were talking about. There is a degree of speeding. There's like the regular speeding everyone does, 5 over, maybe even 10 over. But when you start approaching doubling the speed limit, there is kind of that implied malice that we were talking about. So if you're doubling 70, 140, that's so much more than just speeding 75 in a 70 zone. An 80 in a 45, that's nearly double as well. So it depends again on what the specific laws were here, but I agree.
Yes.
Erickson got off incredibly easy. And if anyone's getting special treatment, I think it's him because of what his resolution was. The judge, he is capable of probably spending a lot of money on some nonprofit. All he had to do was basically a scared straight talk to high schoolers.
I was shocked.
Right?
Yep.
So I know that this focus has been on Rebecca getting special treatment because of socialite. I would say that both of them did. He is clearly a famous, retired pro athlete who that may have factored in here, whether he had a good PR team, whether he had more public opinion on his side because people really loved watching him play ball back in the day, whereas Rebecca is just another rich lady who won awards. Who knows? But I would say that both of them kind of got special treatment here.
Yeah, I think that's a good point. And there's really so little spoken about with Scott Erickson. He just kind of disappeared into the night. So as I mentioned just now, Rebecca was going 81 in a 45 just seconds before the impact, but the data from the vehicle showed that she did tap on the brakes right before the time of the crash, but that only brought the car down to 73 miles per hour. So it was just going too fast to, for her to even stop. In the defense's closing arguments, they said that Rebecca was traveling 54 miles per hour at best. I'm not sure where they got that number from, given that the car's data said nothing of the sort. Well, they also disputed the prosecution's contention that she was impaired and left the scene. Busby, the defense attorney, also said that authorities failed to properly investigate the crash to determine who actually hit the boys. Again, I think the damage to the cars and the eyewitnesses tells a story, but I do think that they should have looked further into how Erickson's driving contributed to the accident. The defense says that this case was a rush to judgment and that they put blinders on and basically just saying that someone else was responsible for this crash. The trial lasted about 6 weeks, and on February 23rd, 2024, Rebecca was ultimately found guilty of 2 counts each of murder and vehicular manslaughter with gross negligence and 1 felony count of hit-and-run driving. Initially, she was supposed to be sentenced in early April of 2024, but this got pushed back to June 10th. And as of this recording, in late May, we have yet to see what happens in the sentencing. But I want to take a minute to talk about what she is facing. Now, right now, it seems that Rebecca is facing 34 years to life. Now, how do we get to that number?
So that's what everybody reported, that she's facing 34 years to life. And one thing I'll say, not an expert in California law, but one thing that the media tends to get wrong is they stack everything as if everything's going to run consecutively. So here's what she was convicted of. She was convicted of 2 counts of second-degree murder. That's a 15 years to life sentence. So she's supposed to get at least 15 years. So it's 2 counts.
Okay, so let's say 15 then.
Okay, well, it's 2 counts. So 2 times 15 is 30. So that gets you up to 30.
But Brett, usually they would run consecutive.
Well, it depends on whether they would run consecutively or concurrently. But assume for a second, it's just 2 times 15, that's 30. Okay. So then the gross vehicular manslaughter is a 2 to 6 year thing. So 2 times 2 is 4, so that gets you to 34. And then hit and run is up to 3 years with no minimum. So that's where people are getting 34 years to life.
Gotcha.
It's the 2 counts of second degree murder, 2 counts of vehicular manslaughter. I think she's actually facing 15 years to life, because usually judges do have the discretion to run all counts concurrently. I looked into this a little bit in California law. I couldn't find anything that made these mandatory consecutive sentences such that you would have to run them consecutively. Sometimes when it's a murder case, judges like to impose sentences for both victims, but they could do things like 20, do 20 years instead of 15. So I don't think that it's actually true that her minimum sentence is 34 years, though it's possible there's something in California's sentencing scheme that requires you to run certain kinds of charges consecutively. And consecutively means each sentence has to run, so you'd have to do the 15 years. Like, let's say that she got the minimum on all these. A consecutive sentence means she has to do the 15 years for the first murder. Then when that 15 years is up, she has to do the 15 years for the next murder. And then when that 15 years is up, she has to do the 2 years for the first count of gross vehicular manslaughter. And when that's up, she has to do the next 2. That's what consecutive means. If it runs concurrently, then every day that she's serving for one of the second-degree murder counts, she's also serving that for the other second-degree murder count and for the gross vehicular manslaughter. A few things that come into play. She has no prior criminal history. These are just things that judges consider when they're thinking about whether to run something consecutively. No prior criminal history. This is one incident, so it resulted in 2 deaths, but it was one incident. And those are 2 factors that a lot of times, if a judge is deciding, could lead to running these concurrently. So I would say, unless, like I said, there could be a quirk in California law. If there's not, she's probably actually facing 15 years to life.
Alice, do you think that's the appropriate sentence for her?
So that range is set by statute, which is set by the legislature. That, in terms of minimums, is not at the discretion of the court. What the court does have a discretion is within that range, 15 to life. If you think it's not just going to be for her case, it's not just because it's Rebecca who got convicted of second-degree murder that her minimum is 15 years and then up to life. So it's a broader question, not as to whether it's overly punitive for Rebecca, but what we think about second-degree murder writ large. And we were talking earlier about how every criminal defendant should be treated the same. The fact that all second-degree murderers are facing convictions for second-degree murder are facing the same range, I think is appropriate for Rebecca. Now, if we're talking about whether as a policy that is something Californians want, would be different, and that should apply to everyone who's convicted of second-degree murder, not just Rebecca. And, Brett was saying that when it comes to sentencing, there are going to be a lot of factors. And another factor, in addition to her having no criminal history, is her age, right? We often look at risky behavior decreasing as you age. She's in her mid to late 50s, I think. Let's round up and say she's 60. If she serves the minimum of 15 years, that brings her to 75. There are plenty of risk-loving 75-year-olds, but typically when we look at statistics, the risk of additional recidivism or risky behavior tends to decrease as you get older. And so I would say probably, essentially, she is serving life, right? In terms of what the average age that women live to in the United States is 78, something like that. So in a lot of ways, she is getting a life sentence. Now, we'll see what the judge will say in this case. She has very good attorneys who will make all of the arguments that we've kind of raised as to why she's not really a danger to society and that she should be getting something way less than even 15. And anything she gets should definitely be concurrent. That's what they're going to argue. I can imagine the judge may go something above the minimum because of the loss of 2 young lives here and the continued lack of remorse and the lack of acceptance of responsibility that has continued is probably going to work against her. Judges do not like this, especially after a conviction by a jury. The continued lack of acceptance of responsibility is something that irks a lot of judges.
And, just the other thing, we talk about this sometimes. Defense attorneys are supposed to be zealous advocates for their clients. Sometimes that means convincing your client to plead guilty. And she really needed to plead guilty in this case. Now, that may be her, not them. They can only do so much. She really needed to immediately accept responsibility, plead guilty, and beg the court for a sentence low enough that she might get out one day. Because as Alice pointed out, she's older. And she has lots going for her, right? She does have her age. She has no criminal history. All of those good things she did in the past, the philanthropy and the donations and the awards, like all that would be in her favor. And if she's like a total mess, crying in the courtroom, all of that could have gotten her to a place where I think she would have gotten the minimum. We're not seeing any of that. And I think Alice is right. I don't think she'll get the minimum at the end of the day. Now, I don't know if she'll get what people think she should get, because I think people want them to put her under the jail. But I do think she'll get more than the minimum because of how she's approached this after the crime.
I agree. I think, a woman of her means, she could give money to a foundation in the honor of the 2 victims. There's so much she could have done to give back to the family. Of course, nothing will give the family back their children, but she certainly could be doing a lot more. And there's so many different purposes of punishment, right? So you were talking about like incapacitation. Is she a threat to public safety? Probably not. Specific deterrence. Is she going to offend again? Probably not. But I'm also wondering how general deterrence is going to work into this. Will they try to make an example out of her? Because street racing is a big problem in Los Angeles County. So I wonder how much that's going to play into it. And I think restitution and, closure for the victim is going to play a big part also in the sentencing. We'll definitely keep an eye out. I'm more curious about what the judge is going to say and if they're going to go over that minimum. The conversation does not end here. While we wait for the sentencing, there is a lot going on. In a recorded phone call 2 days after the verdict, Rebecca told her estranged husband, "You should call Scott Erickson and tell him to get on a video and that he needs to confess. I have a family." Peter responded, quote, "I know he needs to confess, but right now I can't even talk about the case, but that guy needs to. You're in jail for him and it drives me crazy." He also warned her that they, quote, "have to stop talking about the case on the recorded line." So Rebecca's having a lot of conversations from jail. She's made a series of phone calls to, quote, "engage in wholly improper conduct and potentially illegal conduct." Now, these calls were with both her 19-year-old daughter, whom she encouraged to track down witnesses to get them to say that they were coached, and also with her husband, as I mentioned. In these calls, Rebecca says that the jury was the worst and they were not on her side from the beginning. I guess she doesn't realize that that's a good jury. No jury should be on your side from the beginning. So in March of 2024, a Van Nuys judge rejected the prosecution's request to revoke Rebecca's privilege to make telephone calls while behind bars. Though it wasn't upheld, Rebecca was cautioned that her phone call privilege could be revoked at a later date. The judge also ordered the defense to destroy any record of personal identifying information of jurors. Now, this happened because there were many complaints from jurors that they were approached by a private investigator who is working for the defense. What is going on here? What is Rebecca doing?
So because she's convicted, she now is in jail. Remember, we talked about the $2 million bail previously before there was a conviction. Mm-hmm. Once you're convicted, your rights change. She is a convicted felon. And so she is held in jail. And while in jail, you do have certain rights to make phone calls. And as Rebecca knows, because she said it on the line, yeah, all jailhouse calls are recorded. Mm-hmm. If it's an attorney-client privileged call, no one can listen to it, but as a default, just about every jail in the country automatically record calls because oftentimes evidence like this comes out. The coaching, asking her daughter or anyone to threaten witnesses is obviously not allowed. Mm-hmm. I can imagine because she doesn't have a criminal history other than what she's just been convicted of, the judge wants to scare her into compliance. Before she has her rights to all of outside contact revoked by not being able to make calls, I can imagine the judge gives her a warning, and that's what this is. If she violates it again, I don't think the judge will have any patience and may revoke that. But do remember that this is her only contact with her family, and she does have a family who she clearly often speaks to. Now, with respect to the juror issue, you cannot have any contact as the defendant or the attorneys, so the defense counsel or the prosecution, with the jurors during the trial. There's supposed to be no contact whatsoever. Once the jury reaches their verdict, and they are now again kind of free people in society, they are allowed to speak to whomever they wish. They can go on Dateline. They can go on, the next morning's talk show if they want. They can write a book. They can do whatever they want. They don't have to. It is their prerogative whether they ever want to speak. So it is not against the law for anyone to reach out and say, hey, were you on the jury? Would you like to speak? But you can imagine that can cross the line into threatening someone if they've said, I don't want to speak with you, and they continue to be approached by, say, defense counsel in this case. So it's a little bit of a murky line because you can't kind of have these bars to communication because your jurors are made of regular citizens. Typically, the decision is left to the jurors whether you want to speak to anyone or not. But we have had instances where jurors feel threatened or harassed, and they will go back to the court for help. In those instances, the court will typically try to take some action because we want to protect the jury system. They didn't volunteer to be jurors. They were called to be jurors. And we want to protect that system against harassment.
I think this just further illustrates a sense of entitlement, some grandiosity, arrogance. She seems to be leveraging her status. She still won't admit to anything. She's trying to pull strings from jail. I don't think any of this is going to work for her during sentencing. I think this is the time for her to just kind of go under the radar, follow the rules. And I'm wondering if something like this is going to affect her sentencing. I guess formally it can't. Is that correct?
No, it can.
It can. Formally.
Yeah,
okay.
I mean, number one, depending on the facts of this, the prosecution could ask for an obstruction of justice enhancement, which most states have, where basically you say, look, in addition to everything they were convicted of, they're also obstructing justice. Now, the defense would argue, as Alice was saying, that we're really just trying to see if there was prosecutorial misconduct in coaching the witnesses or jury misconduct. You know, it's kind of like those people who followed the Murdaugh trial may know, the defense did the same thing in the Murdaugh trial. They went and talked to every juror, and they got something out of it. They were able to get a hearing because of it. So that's what they would say they're doing. But if a judge thinks that she's actually trying to intimidate and harass people and engaging in obstruction, that is absolutely something the judge can take into account when thinking about a sentence. And frankly, judges can take just about anything into account. A judge has vast discretion when deciding that 15 to life, where this should fall.
Yeah, that's true. When you're looking at an upper limit of life, that really gives you a lot of discretion, right? That's a long time between 15 and life. So as of now, Rebecca awaits her sentencing. As mentioned, it was scheduled for April. It got moved to mid-June. I wouldn't be surprised if it got moved again, but we'll definitely be keeping an eye on this for sure. Meanwhile, the Iskander family tries to pick up the pieces and move forward. The Mark and Jacob Iskander Foundation has been created by the family, and this provides support to underserved children to help children reach their full potential academically, socially, and psychologically by offering them the love, support, and tools that they need to succeed. A GoFundMe was originally created to support the family, but now they're collecting funds for the family to create a foster family agency. As it reads, quote, in partnership with the Good Shepherd Foster Family Agency, the Iskander family will be opening a foster family agency in the Thousand Oaks, Westlake area. Our goal is simple, to provide a haven for children in need and a lifeline of support for foster families. I haven't seen if it has actually opened yet. It was scheduled to open at the end of 2023, but it seems like it's still in the works. From what I saw, the Iskander family was matching donations up to $20,000. So I urge you, if you are interested, to check out the foundation. As they say, quote, because of Mark and Jacob, more of God's children in Ventura County will have a home. So I'm sure the family is anxiously awaiting the sentencing to perhaps have some sense of closure so they could continue to try and move forward from this horrific tragedy. Brett and Alice, a big thank you for joining us today and breaking down the many legal issues that were in today's story. I really could not have done this case without you. Megan thanks you as well for filling in so she can have some much needed time off with her new baby. For our listeners, be sure to check out the hit podcast, The Prosecutors. They also have Legal Briefs, which is another podcast. Is there anything else you guys want to plug? Please tell me you're not working on anything else. I would feel very lazy. Okay, good.
No, Amy, thank you so much for having us. We wish the best to Meg. And we love your podcast, and we feel so honored to be able to discuss this case, this very tragic case with you.
Thank you both. You really taught me a lot in this episode. So if it's okay with you, I would love to have you back sometime.
We would love that.
Hi, listeners. As promised at the beginning, I am back to give you a brief update. On June 10th of 2024, Rebecca Grossman was sentenced for the deaths of Mark and Jacob Iskander. Now, if you recall, the maximum penalty for these crimes was 34 years to life, and that is for each charge. The judge in this case sentenced Rebecca to 15 years to life to be served concurrently. Now, Nancy, the victim's mother, has publicly stated that this ruling denies full justice, as both of her sons were murdered. However, the murder sentences running concurrently treats the two children as one. At the sentencing, the judge remarked that he believed that Grossman's crimes were not intentional, and he added that, quote, her conduct and state of mind barely meet the requirement for implied malice in California. So basically, the judge chose a middle path between what the defendant was asking for, which was probation or a lighter prison sentence, and what the prosecution was calling for. Lastly, it was clear that the judge was influenced by the defense's presentation of Grossman. If you recall, she was a humanitarian who adopted a young Afghan burn victim, and she also demonstrated generosity in her life before the crash. So the judge said that the prosecution's attempt to portray her as, quote, a monster was simply not true given her prior acts in the community. Most recently, on June 21st, 2024, a now 61-year-old Rebecca was transferred from LA County Jail to a prison in Central California. We will keep our eye on this case and see what Rebecca does while she is incarcerated and if she finally issues an apology to the victim's mother. As Nancy has said, she is still waiting for that apology. Thank you again for listening, and we will catch you next time on Women in Crime.
Women in Crime is written and hosted by Megan Sachs and Amy Shlosberg. Our producer is James Varga. Script editing is by Abagail Belcastro. Audio editing is by Seiler, Burr, and Jose Alfonso. And music is by Desert Media. If you enjoy the show, please remember to follow and leave a review. You can also support the show through Patreon, where you can get access to additional ad-free content such as exclusive full-length episodes, lectures, a book club, and virtual happy hours with Megan and Amy. For more information, visit patreon.com/womenandcrime.
Sources for today's episode include the Los Angeles Daily News, justiceformarkandjacob.com, NBC Los Angeles, FoxLA.com, LA Magazine, LA Times, the Acorn, and the Grossman Burn Foundation.